Hello and good evening, everyone. My name is Joshua Beckles, and today I will be discussing my case analysis on Ricci versus DeStefano, which was ruled by the United States Supreme Court. To begin, this case involves a little bit of reverse racism. A lot of times we think of reverse racism as a stereotypical scenario or situation where the majority group is acting similarly to what a minority group um, or ethnic person would act or conduct themselves. In this case, it's a little bit different. The reason as to why is it's a matter of an unintentional, rational action that led to the reverse racism that we will be discussing in this case of Ricci versus DeStefano. So to begin, the city of New Haven, Connecticut's firefighter department held its rare and highly valued promotional exam. Ricci versus DeStefano is centered around the results of 118 eligible candidates who had studied for 2 years in preparation of this exam. The results skewed heavily in favor of the white candidates in comparison to the Black and Hispanic ones. To avoid facing disparate liability lawsuits from the minority candidates, Mayor DeStefano and New Haven city officials deadlocked and ultimately did not certify and threw out the exams. Frank Ricci, a white firefighter, and 17 other firefighters sued under Title VII of the Civil Rights Act of 1964. Title VII protects employees and job applicants from employment discrimination based on race, color, religion, sex, and or national origin. Ricci argued that he and 17 other candidates were denied the promotion because of their race. DeStefano said that the certification of the results would have favored one racial group over the other and in turn violated Title VII. As we see, um, or as we would later find out, the federal district court upheld New Haven's decision, stating and citing that the city of New Haven had not acted out of discriminatory prejudice because all eligible candidates took the test and the result was the same for all because none of the candidates had passed the exam. Before going further, I would also like to go ahead and discuss what exactly is disparate impact liability. Disparate impact can also be referred to as adverse impact, which are practices that are non-discriminatory on the face value but have disproportionately negative impacts on individuals of legally protected groups. McDonnell Douglas Court versus Green is a case in which the United States Supreme Court developed the mandatory pieces of disparate impact in Title VII, involving the rights of a Black mechanic, Mr. Green, who was laid off and not rehired. McDonald claimed he was not rehired because of a lock-in participation to protest racial inequality. SCOTUS held that the plaintiff belonged to a racial minority group. Two, the plaintiff applied for and was qualified for a job with the employee. Three, the plaintiff, despite job qualifications, was rejected. Four, after the plaintiff's rejection, the job remained open and the employer continued to seek applicants. Note that the company must show that it is a business necessity before engaging in employment practices that are non-discriminatory. A short while after the federal district court's ruling, Mr. Ricci appealed their decision. Ricci and the 17 other firefighters maintained their position, stating that they are protected persons under Title VII. The Second Circuit affirmed the district court's decision, which was extremely interesting to me in my findings. Their ruling sent an unpublished summary order that was later rescinded and replaced with one identical to that one provided by the district court. The controversy from the Court of Appeals decision to come based on the lack of substantive evidence could have opened the door to challenge affirmative action and civil rights law. Affirmative action is a system that eliminates unlawful discrimination among applicants remedy the results of such prior discrimination, and prevent it from reoccurring. Created under JFK's executive order, it established the Committee on Equal Employment Opportunity and mandates that projects financed with federal funds take affirmative action to ensure that hiring practices are free of racial bias. The United States Supreme Court overturned the Second Circuit and the Federal District Court's decision, ruling in a 5-4 decision. The reasonings as to why was because they mandated that before acting to prevent disparate impact liability, the employer must have evidence that they will be subject to a disparate liability. SCOTUS went on stating that Ricci and the 17 other firefighters were denied promotions because of their race. Fear of litigation is not enough credible evidence to justify possible disparate impact. Note that DeStefano and the City of New Haven did not provide a substantive alternative test either. New Haven took great lengths to ensure that their test was accurate and valid multiple months prior to the exam date. However, they chose and elected not to acknowledge the validity of the exam that was vetted rigorously. Rather, city officials made the decision to engage in facially neutral employment practices. I leave you all with two underlying questions that this case presents. The first being, can a city reject results from an otherwise valid civil service exam when the results unintentionally prevent the promotion of minority candidates? And also, does the United States 42nd United States Supreme, let me start over, ladies and gentlemen. Does the 42nd United States Code Section 2000E on unlawful employment practices permit federal courts to relieve cities from having to comply with local laws that require strict compliance? Both questions are completely based and answered on their evidence provided in their respective cases. If New Haven had shown that not certifying the exams was a business need with evidence, it's possible their actions would have been justified. Lacking that information, New Haven was unable to justify their actions to not certify the results regarding Ricci versus DeStefano. That is not the case, as they could not prove disparate impact liability. All in all, I just want to say thank you all for tuning into my case analysis, and I hope you took a great takeaway from this case. Thank you so much, and have a wonderful rest of your semester.